Edward Macmillan-Scott, Liberal Democrat MEP for Yorkshire and the Humber. What's your reaction in this case? We hear that the European Court of Human Rights has decided there was no violation in the case of access to court involving Sandy Mitchell and his claims that he was tortured in Saudi Arabia. Your reaction?
It's disappointing because Sandy Mitchell is my constituent. He was tortured and imprisoned for a long period in Saudi Arabia, a country where there is no justice, and where, had he finally got the death sentence, he'd been beheaded and left to rot as an example to others. It's that basic. And I think there's been a sort of sense that the House of Lords judgment and that of the decision by the Foreign Office, the establishment in London to protect Saudi somehow, it's not the first time this has happened. But I think in a globalizing world, we need to find some new way of dealing with inhumane and degrading treatment, and especially torture. You know, the Snowden revelations and others are beginning to shape opinions, not just here but in the United States, towards torture. It is not the right way of going forward ever, and especially today. And what I'd like to see is, at a European and international level, an immunity or impunity index, like they had during the Cold War between East and West Germany. So prisoners being tortured in East Germany could denounce somebody, the torturer, and when finally democracy came to Germany, there were literally hundreds of trials. And so we need, at an international level, through the International Criminal Court, an impunity register so that anybody being tortured anywhere in the world knows they can denounce the torturer, and one day justice will prevail. In the short term, however, the European Court of Human Rights is a bit of a soft court. It has nothing to do with the EU, but it does give these judgments. They're persuasive rather than binding, and we tend to accept them in the United Kingdom. I don't think in this case it's really helped the thing further at all. And, you know, if you've got one of the judges dissenting and saying that the precedent has been set for using immunity in a wider sense, this is quite the wrong way to go. Immunity from prosecution in cases of torture should never exist, whether it's a British civil servant, a British officer, or anybody within our system. Torture is absolutely a no-no.
Then I wanted to pick up on this idea that you have of an international setting in taking up these cases. So with your idea, would state immunity be a reason to withhold justice in torture cases like this, or would your idea of an impunity register deal with that issue?
There will be no immunity. There will be no sovereign immunity. There will be no state immunity. Today's world, impunity, to use that term, immunity, no longer exists. This was a definition made, incidentally, in the United Nations by our ambassador in 2005, so it's nothing new. But how to actually put it into practice is the question. And I believe that the International Criminal Court in The Hague, which has been operating since 1992, dealing with cases in many, many countries, many jurisdictions, whether it's Sudan or Sierra Leone, is effective, is demonstrating its worth. The one current failure is the United States do not belong, but one day they will. Once that's happened, then anybody on earth who is torturing or using inhumane or degrading treatment should be aware that one day they may face justice at the International Criminal Court.
You mentioned there that one of the judges had disagreed with the judgment, and I understand that that particular judge suggested that this could have a wider impact. Without the kind of system that you'd like to see set up, is that a concern that you would share, that state immunity could be used almost as an excuse to avoid torture cases coming to court?
Yes, because I mean, every case is different, but there's one thing we know, which is that torture, A, doesn't work, because the results you get from torture are simply not reliable. But secondly, it is completely banned by all international conventions. And the sense that it's somehow tolerable has gone now. We all know what's been going on in the last few years. We're all ashamed of it. But so far, London hasn't quite picked up. And I think it's time that London did. Internationally, torture must be banned. And the only way to stop it, you can ban it, but you can't stop it. The way to stop it is to tell people who are doing it, your name has been taken. One day you'll face justice in the International Criminal Court or in another court, but certainly internationally that's where it should be.
What then would you say are the options left to your constituent in the current circumstances that he now faces, which is the judgment from the European Court of Human Rights?
Well, it remains to be seen how it's dealt with by the UK authorities, because, as I say, these are not binding, they're persuasive judgments, and sometimes helpful, sometimes unhelpful. It's got nothing to do with the European Union, so often confusingly linked with us, because we, unfortunately, as MEPs, have to meet in this city, Strasbourg, once a month. It's got nothing to do with the EU. I think that the likelihood is that the government will allow the waves to close over this case. Nothing will happen to Sandy Mitchell, I hope, but if he's got problems, he must come to me or to his own MP, I know he's been in touch with her, and make absolutely sure that his case is kept in front of people, because it actually represents quite an important symbol. Here we have, broadly speaking, the London establishment backing the Saudis, a terrorist regime, if ever there was one, using appalling techniques, not only against our people, but against its own people. It is not a democracy. It is, yes, a very rich country. That is not an excuse for exonerating torture.